My name's Matthew. I'm the team leader of the Tenants Advice Service here at DCLS. And what I want to talk about today is a couple of things that we're getting through, particularly for us, around what's remaining of the COVID-19 modification notice that affected the Residential Tenancies Act, and also around rent increases. Obviously, with such a tight rental market at the moment, what's happening, we're getting lots of inquiries about when rent increases can occur, and particularly rent increases occurring on things like periodic tenancies. So first of all, I'd like to acknowledge the traditional custodians and land in which we're meeting today, the Larrakia people, and pay respect to elders both past, present and emerging, and extend the respect to all Aboriginal and Torres Strait Islanders people here today. A little bit about us. We're the Tenants Advice Service. We're part of DCLS. It is a free and confidential service for every tenant in the Northern Territory. We do not advise landlords, we only advise tenants. And we work to advise on problems with landlords and real estate agents, negotiate and advocate on behalf of the tenant with landlord or real estate agents, assist with advice, documentation and representation before the Northern Territory Civil and Administrative Tribunal. We also conduct community legal education about tenants' rights and responsibilities, and we lobby to improve tenancy legislation and policy. So that's pretty much us in a nutshell. So as I said before, the topics I want to talk about today are what's left from the COVID-19 modification notice in residential tenancies and the increases in rent. So the COVID modification notice, it affected all residential tenancies in the Northern Territory covered by the Residential Tenancies Act. But during COVID-19 modification notice, which was gazetted on the 28th of April 2020, and it modified the Residential Tenancy Act. The modification notice ceased on the 15th of June this year. Now, the way it actually modified the Residential Tenancy Act, both fixed term and periodic tenancies were given 60-day termination notice for any tenancy during the COVID modification notice period. Termination notice was given after the 16th of June this year, only require 42 days for fixed term and periodic if they were signed during the COVID or during or before the COVID-19 modification notice period. However, all tenancies entered into after the 16th of June this year, the RTA applies. Now, with the RTA, that means that a fixed term tenancy only requires 14 days to be terminated by the landlord or the tenant. And in a periodic tenancy, it requires 42 days by the landlord and 14 days by the tenant. One of the other things that continues on from the COVID-19 modification notice period is that repairs. Now, in a tenancy, there is two types of repair, one being an emergency repair and the other being an ordinary repair. Now, emergency repairs are things like no power, no water, no toilet facilities, no cooking facilities, gas leaks, anything that's a threat to life and limb, or anything that unduly inconveniences the tenant. Now, they're classed as emergency repair, and they should be completed within 14 days of notification. Everything else is deemed as being an ordinary repair, and it should be completed within 21 days. However, during the COVID-19 modification notice period, an emergency repair still had to be completed within 14 days. However, ordinary repairs should be completed within 60 days. Any repairs reported after the end of COVID modification notice period, the RTA applies, so it goes back to 21 days. So there is that small matter that if a repair is reported during the COVID-19 modification notice period, then 60 days can be applied for an ordinary repair. However, once after the modification notice period, it's back to 21 days. So that's pretty much all that's left that still continues on from the changes that happened during COVID. And obviously, as those tenancies run out, there'll be less and less of those issues coming up. As I said, it only applies to tenancies that were signed during the COVID modification notice period or before the COVID modification notice period. All those signed since the end, the RTA applies. Which brings us on to one thing that we're seeing more and more coming up. Now, obviously, at the moment, I think we're running at a 0.5% vacancy rate in tenancy, which makes it incredibly hard for people to find places to live. And it very much makes it a market that favours a landlord over a tenant. Now, one of the things I can speak in a bit of personal terms of this, last time I renewed my tenancy, they tried to increase my rent by $160 per week. Strangely enough, I negotiated and got it down to $60 a week, but we're seeing increases of 20% up to 50% more in rents. One of the things we're seeing is that there's a great misunderstanding around when a rent can be increased. And we just wanted to make sure that people are aware, or if they do find people that are being reported this, that they're aware of what can and can't be done. So rent can only be increased if it's in compliance with the Residential Tenancy Act. Section 41 of the Act outlines when increases can take effect during a tenancy, but it should be noted there is no limit to a rent increase in a new tenancy agreement. As I said before, when my tenancy expired, they tried to get me to sign a new lease of $160 increase. Because it was a new agreement, there is no limit to what they can put on it. It comes down to negotiating with your landlord or real estate, or obviously choosing to live somewhere else. As I said, it's something that makes it difficult, obviously, in a tight rental market. There is some times when Section 41 does not apply, and the Act specifically states there is 2 times. It's tenancies under the Housing Act, so all public housing, as set out by agreement or termination by the Minister, who administers the Housing Act. That's because obviously when there's rent rebates done or anything to that nature, it may make the rent go up and down, so it's exempt from Section 41. And it goes on that if the increase of rent is because of a cancellation of adjustment of a rent rebate. Now, that may be outside of the Housing Act, particularly in NRAS housing, which is National Rental Assistance Scheme, which is currently coming to an end in some areas. So be aware that if it does come up and it's a cancellation or adjustment of a rent rebate, it may not be covered by Section 41. So what does Section 41 say? Now, there's some great words in Section 41 because it's very, very specific. A landlord may increase the rent payable under a tenancy agreement only if the right to increase the rent and the amount of increase in rent or the method of calculation of increase in rent is specified in the agreement. So what it's basically saying, the right to increase rent is not in the lease, then there is no right to increase the rent. Now, in most agreements, it'll actually have rent increase to take effect from X, and it should be something. However, the right to increase is in the agreement, but if it's vague or uncertain, so if the terms market rate are in there, it still has no right to exist, because the whole bottom line of it is that it's got to be able to be calculated by both parties. Now, market rate normally is only calculated by the landlord, so therefore it's seen as being vague. It should be put down as either a percentage, a dollar amount, or something that's a known figure. An example of that would be saying the third quarter CPI increase of the previous year. That way, it's something that's open clearly and unambiguously to both parties. Part 2 of Section 41, the date fixed for an increase in rent in relation to a tenancy agreement is of no effect unless at least 30 days written notice is given to the tenant of the amount of the increase and the date to which the increase is to take effect. Pretty straightforward. Must be 30 days, must be in writing. And there is a thing that's available, and it's available on the Consumer Affairs website. It's an RT10 notice, which is a notice of increase of rent or bond. This meets all the requirements of the Act, and it's one we see most used. It should be in writing and must include the date of increase and the amount of increase. So it doesn't have to be an RT10, but they're the things it must include. Now, unfortunately, things like an email that does have the name of the tenant, the address of the property, date of increase, amount of increase, can be deemed as being valid. Section 41(3). The date fixed for an increase in rent in relation to a tenancy must not be earlier than 6 months after the day in which the tenancy agreement commenced, or if there has been a previous increase of rent under this section in relation to one or more of the same tenants in the same premises, the last increase. So a rent cannot go up if there's a rent increase within the last 6 months. Now, as I said, this does not apply if it's in a new lease. So if you had a 6-month tenancy agreement, they can stick up the rent every 6 months because it's a new agreement. However, if it's in a singular agreement, let's say a 1-year agreement, and they try to put up the rent in 6 months and then again at 9 months, they're not allowed to do it because it must be with no earlier than 6 months. The last part of section 41 is if the rent payable under the tenancy agreement is increased in this under this section, the terms of the agreement are varied accordingly. So they don't have to go back and readjust the lease itself. All they have to do is say, we've done all the notices under section 41, therefore the lease from now on is the higher amount. Now, some defences that, or at least some ways that a tenant may be able to keep the rent lower. Under section 42 of the Act, the tenant may apply to NTCAT to declare the rent increase excessive. However, if there is an application under this, the tribunal must consider comparable tenancies in the same or similar locations and the level of services provided by the landlord to the tenant. As I said, at the moment, because there's such a tight rental market, this is very difficult to prove because rents everywhere are going up. It's only if there's been, for example, something like previously I could use the pool, now the pool's busted, I can't use it, then it may be looked at as being excessive, particularly if there's services being withdrawn or something's gone down compared to the services provided. However, comparable tenancies at the moment are showing that rents are going up across the board. Now, recently we've had some changes to what NTCAT believes is the common law for rent increases. We had some previous precedent was established in 2 cases, which are widely commented on and widely used, particularly when it comes to landlords of real estate saying that they're allowed to increase the rent, particularly in periodic tenancies. The 2 cases that were previous precedent were Holders Investments Proprietary Limited and Ivinson and Halliday from 2009, and Bertoli and Weber from 2015. Now, in Holders, it relies on common law contract principles where parties can increase the rent by consent. It found that section 41 did not apply to periodic tenancies. What happened in that situation was there was a long-term tenant and landlords had basically signed an MOV that allowed them to increase the rent every year, and it was by consent of both parties. So as I said, that one relied on common law contract principles, basically saying if both parties agreed, they can increase the rent. Bertoli also agreed that section 41 did not apply to periodic tenancies, but found that rent could not be increased unilaterally by the landlord. Now, that became important because it actually then cemented Holders into the idea that periodic tenancies, he could have the rent increase, and it was done basically on a between payments of rent. So it was seen that every payment of rent was seen as being one tenancy, and that at any time the landlord could, either with agreement of the parties, increase the rent. And as long as the other party kept paying, it was totally legit. However, recently, in 2020 and 2021, we ran two cases here that overturned those precedent. The first one was Billingsley and Beale, that was in 2020. The other was Sutton, Chenham, Burslem and Burslem. Now in Billingsley, this overturned Holbert by finding that common law has no power to override the Act. It also found that Section 41 must be applied in regard to fixed term and periodic tenancies to increase rent. Now, this is quite an interesting one. In Billingsley, the landlord basically told the tenant there was got to be a rent increase. The tenant started paying it, and then the landlord decided to retrospectively make it apply to the start of the tenancy, and then said that the tenant owed him a heap of money. We actually were representing Mr. Billingsley in this case, and we actually challenged there was no increase valid under Section 41, and the tribunal found that that was correct and that Holbert should be applied, and that because the statute had actually overridden common law, that common law or contract common law couldn't apply. Now in Burslem, it confirmed Billingsley. It found that common law right to increase rent is abrogated by the Act. Section 41 applies to periodic tenancies. And if an original fixed term tenancy had no right to increase rent, then neither does the periodic tenancy if Section 83 applies. Now, just a brief one on that one. In Burslem, Mr. Burslem, who was our client, had a fixed term tenancy. Now, Section 83 of the Residential Tenancy Act states that if a fixed term tenancy is not terminated, it automatically becomes a periodic tenancy. Now, in Mr. Burslam's case, he had a fixed term tenancy which had no right to increase the rent in it. Section 83 states that the fixed term tenancy becomes periodic at the same terms. So if there was no term to increase the rent in the fixed term, there is also no way to increase the rent in the periodic that follows. So this has become important a lot because basically what's happened in a lot of cases is that someone's fixed term tenancy gets to the end, it has become automatically periodic, and then the landlord or real estate think they can actually increase the rent accordingly because they want to make some more money out of it because rents are actually a little bit more expensive now. However, it's been proven that it can only happen if it's in compliance with Section 41. Now, the Act does agree that rents can be adjusted by mutual consent, but only if the rent is going down. Now, this occurred quite a lot during COVID when it was done by mutual agreement that rent would reduce during the tenancy, particularly if the person was stood down due to COVID reasons. However, it can be temporary and can revert back to the original level at the end of the specified period. So that means if there's been an agreement between the landlord and the tenant to reduce the rent for 2 months while they're obviously being stood down, it can automatically revert back to the original level. It's not a rent increase, it's only going back to the original level that was in the lease. It can't go higher than that. And in the same way that the COVID modification notice started, is that it didn't abrogate the tenant's right, the landlord's right to claim that lost rent during that period. However, this actually does allow for the rent to go down, but not go up. So what does it mean to tenants? Rent cannot be increased unilaterally. The landlord or real estate cannot just turn around to the tenant and say, I'm putting the rent up. Rent cannot be increased by mutual agreement. Rent, however, can be decreased by mutual agreement. No restrictions on rent applies if it is a new lease. However, Section 41 applies to both fixed term and periodic tenancies. Rent can only be increased if specified in the lease, and it must be very specific. It must, as I said before, be a dollar amount, a percentage amount, or at least something that be calculated by both parties, i.e. CPI increase second quarter of previous year. There must be at least 30 days written notice of a rent increase, and the increase cannot be within 6 months of the start of the tenancy or the last increase. So I'll just give you some examples. So as I said, this can get quite confusing at times when people are ringing up and saying the rent's gone up, oh, this is terrible, what's going on? And we have to ask quite a few questions to find out whether it is a fixed term lease, whether it's a new lease, or whether it's a periodic lease, because they always make a difference in when a rent can go up. If someone has reached the end of their fixed term lease and they have been offered a new lease or a new memorandum of variation in that lease, there can be an increase in rent, and there is no limits to how much that rent increase can be. Obviously, it then becomes a negotiation. I like to tell people it's a little bit like buying a t-shirt in Bali. They put out their best offer, you come back with your best offer, and hopefully you meet somewhere in the middle. As I said, this is what I did in my situation. As I said, they gave me a rental increase of $160 a week. I almost fainted. But then what happened was we went backwards and forwards for a period of time, and it come down to $60 a week, which I found at least more palatable. If it's an expired fixed term lease and there has not been a termination notice, it has automatically become periodic. If that's the case and the original fixed term lease did not have the ability to increase the rent, there is no ability to increase the rent. If the original fixed term lease did have the ability to increase the rent can be increased as long as it's compliance with section 41, i.e. written notice in 30 days, not excessive, and also that it's not occurred within the last 6 months. And the final one is periodic. If it's a fixed term that's turned periodic, as I said, it's got to have the ability to increase the rent in it. If it's originally a periodic, i.e. you've just signed an open-ended tenancy agreement, if the right to increase the rent is in it, yes, the rent can be increased. However, if there is no right to increase the rent, then there's no right to increase the rent. That happens a lot. The Act basically states that if a lease agreement is not in compliance with the Act, the one in the regulations applies. The one in the regulations is a periodic agreement. So it's always worthwhile going back and finding out whether the original lease was compliant with the Act. If it wasn't compliant with the Act, then the one in the regulations applies. And as I said, that is a periodic and it does not have the ability to increase the rent in it. So bottom line is, to increase the rent in a tenancy, it must be compliant with the Act. If it's not compliant with the Act, there's no right to increase the rent. What we see a lot happening is that the tenant will refuse to pay the rent increase. And then what happens then is the landlord or real estate will serve them an RTO 3 notice, which is a notice of rent arrears, because they're falling behind in rent, and then try and terminate the tenancy due to rental arrears. What will happen is they'll make an application NTCAT, and then the tenant has to prove that the rent increase was invalid, and therefore they're not in rental arrears. It's happened a few times and it's been successful using that argument because it all comes back to whether the rent increase was compliant with section 41. Other things we do see is particularly expired fixed term agreements. That's happened quite a few times. As I said, with Versum, that was one of the situations there. And the rent was increased. However, the tenant, Mr. Versum, did pay the rent increase. NTCAT found that the rent increase wasn't valid and was reimbursed the extra rent that he was actually he paid. So that's pretty much it for those two things. As I said, there's only a few things left over from the COVID modification notice that still apply under the Residential Tenancy Act. I've given you a fair bit of information there around rent increases, particularly section 41. If anyone does have any questions, please put some notes into the box, and I'll have Al, who's one of my wonderful tenancy colleagues, bring up the screen.
Yeah, to escape from that so we can see the chat.
I have a question while there's one waiting.
Yeah, go.
So in practical terms, then following on, if for example, an expired, a fixed term lease expires and becomes periodic, and as you say, you now can't just increase the rent unless it's in the original agreement. Practically, are you seeing many landlords then say, all right, that's fine, notice to terminate?
Yep. Because the bottom line is when it comes down to putting up the rent, it must be in the lease. If it's not in the lease, they've got a choice. And we see quite a lot where they'll offer a new lease, and they'll give a termination notice at the same time. So your choice is take the termination notice or sign the new lease. Now they're allowed to do that. Unfortunately, now, as I said, tight rental market, and that's when you can still negotiate the new lease, but the termination notice may be valid as well. Yeah.
Looks like we've got any questions in mind.
Well, they've done a fantastic job of describing everything, or you probably couldn't hear a single word I said. I'll run down into the message box. Yeah, just in so I can type a message.
Oh, yeah.
No dramas. Just want to pop it back onto the
Well, you
Yeah,
said
ask.
about the rent increase, if notice is given in an RT10.
Yeah.
Then you said something about an email might be deemed as being valid if it.
emails in writing, and
Yeah.
as long as it meets the criteria of having the names of the tenants, the address of the property, when the rent increase would take effect, and how much that rent increase is.
That's instead of an RT10.
Yeah.
Okay.
As I said, it just has to be in writing. There is a
Yeah.
form that they can use, but you've got to check to see if it was in writing, and if it was available, then actually it can apply. But as I said, that becomes something you would just take care, because as I said, it must be in writing. And of course, as we know, emails can be seen as being in writing. So bring that on to full screen. So if anyone has any questions, queries, or problems, look, feel free to contact us. However, it is a lot of information is on our website, and I will advise people to go and have a look at that. There is so much information there. We regularly refer clients onto that to look at that, if particularly some self-help, and that's at dcls.org.au. Have a look at our tenants advice service page. Lots and lots of information there. We've also got some form letters there about negotiations, about a whole range of other things. The other page that I would suggest you look at is Consumer Affairs. Now, we are having some issues with Consumer Affairs because they're still giving out advice around the tolling and holders. And we're a little bit of discussion about which one is the precedent that should be given out. However, they also have all the RT forms. So when I was referring to the RT03s, the RT10s, they're all available on that website, and there is some information there about tenancies as well. So what's next? If you've got some clients who have identified tenancy issues, as I said, have a look at our website. If you can't assist, look, have no dramas in referring through to us. However, what we do ask is a brief description of the issue, name of the client, and any other tenants on the tenancy, and the name of the landlord, not the agent. Because obviously, as you know, we do have to conduct our checks. And as I said, sometimes you will have landlords that have been previous clients for other matters. We just don't want to get into the situation One thing you should be aware is we don't normally do tenant on tenant, because it may end up giving us a little bit of grief later on. The next one. Just click on this screen. So other than that, if there is any questions, please feel free to contact us. We are currently recruiting for a couple of tenancy lawyers. So if anyone's out there sort of thinking of a career change, please feel free to drop in a CV and cover letter. I'm just saying that because I would love to get more people because our work hasn't reduced, but we just need some more bodies. So bottom line is, thanks very much everyone for coming along today. Obviously, this is a general information. If you do have any specific information on, please feel free to contact us or get your client to contact us so we can give some specific information. And thank you very much. That's pretty much it for today. As I said, if there is any other questions, queries or problems, please feel free to contact us. At the moment, there's 2 of us there. As I said, we're currently looking out for some more. Days closed on the 30th. So, hey, look, if you're looking for something different, give us a yell. But overall, thanks everyone for coming along today.
Thanks for that.